My name is Haney Brollesy, and I'm an immigration attorney, and I'm here to talk to you about L1 status. L1 status is what is called intracompany status, meaning it's designed for intracompany transfers. Someone who worked abroad for a company in either a managerial, executive, or specialized knowledge capacity is being transferred to work in the U.S. for a related company in, again, also a managerial, executive, or specialized knowledge capacity. There are two types of L1s. First is the L1A, which is specifically for individuals being transferred to work in a managerial or executive capacity here in the U.S. Then there's the L1B, which is for individuals who will be transferred to the U.S. to work in a specialized knowledge capacity. What is the difference between those two? The L1A, as I mentioned, is for individuals who worked for a company abroad in either a managerial, executive, or specialized knowledge capacity and are being transferred to work for a related company in the U.S. in a managerial or executive capacity. Managerial typically means an individual who manages other professionals. And the way the Immigration Service defines professionals is individuals who are working in a job that requires at least a bachelor's degree. And typically, or ideally, those individuals also manage other individuals. So the organizational structure should look somewhat like a pyramid, with the individual being transferred at the top. Doesn't necessarily have to be the CEO, but it could be the person at the top of that particular department or division, who then has other individuals reporting to them. And likewise, those mid-level managers have other individuals reporting to them as well. There's also the concept of what's called a functional manager, which may not necessarily manage other professionals, but is managing a critical division or department within the organization. Typically, you'd want to show that in particular division or department is responsible for a high level of revenue for the organization or other critical functions such as research, sales, marketing, whatever it happens to be, and demonstrate how critical that particular division or department is to the organization. The other aspect of the L1A is the executive. A person can also be an executive in the U.S., and the way executive is defined is someone who has a high level discretionary and strategic responsibility for the organization, meaning you develop the strategic vision for the company or your division or department within the organization. You are responsible for the business plans, the financial goals for that either entire organization or division or department within the organization. You develop the policies or procedures for the department or organization as well. The L1B, as I said, is for specialized knowledge professionals, is a little bit more tricky. The L1B means the person worked abroad in a specialized knowledge capacity and is being transferred to work for the organization in the U.S. in a specialized knowledge capacity. Now, the way the government defines specialized knowledge is not the way most people would define specialized knowledge. I've been doing immigration law now for nearly 30 years. I would not qualify for an L1B because my specialized knowledge is, yes, in immigration, but it's not unique to my particular firm or any firm. I can pick up what I do and use it at any other immigration law firm. Immigration law is immigration law. It's not necessarily unique to a particular firm. The way the L1B specialized knowledge is defined, it has to be specialized knowledge of the particular organization, meaning you have unique specialized knowledge of the company's policies, procedures, proprietary information, their technology, things of that nature that, again, are unique to the company that someone else who does what you do couldn't just walk in from a competitor and do the same job. And you'd be coming to the U.S. to apply that specialized knowledge to the organization. Another distinction between the L1A and L1B is the L1A allows an individual to remain in the U.S. for a total of 7 years, whereas the L1B allows an individual to remain in the U.S. for a total of 5 years. Now, you're not granted that 7 or 5 years all at once. Typically, the initial period for either an L1A or an L1B is up to 3 years. The L1A can be extended for an additional 4 years, typically in 2-year increments, and the L1B can be extended for an additional 2 years, making for a total of 5 years. What are the other requirements for L1 status? The first is you have to have worked for the company abroad outside the U.S. for at least 1 year within the last 3 years prior to the transfer to the U.S. And the way the government likes to verify your employment status abroad is by looking at your pay stub. So you would need to provide at least 1 year of pay stubs from the foreign company showing that you worked there for at least 1 year. Another requirement is that the two companies, the foreign company outside the U.S. and the U.S. company, have to be related. There has to be a common ownership structure between the organizations. For example, the foreign company could own the U.S. company, either a wholly owned subsidiary, meaning the foreign company owns 100%, or owns at least 50.1% of the U.S. company. There can be an affiliate relationship between the two companies, meaning one person or group of people or other company owns at least 50.1% of both the foreign company outside the U.S. and the U.S. company. Now, when I mentioned subsidiaries also earlier, it could go the other way, meaning the foreign company is owned by the U.S. company, either as a 100% wholly owned subsidiary or somewhere up to at least 50.1% subsidiary. There could also be a branch or office relationship between the two organizations, but the relationship structure is one of the key requirements of the L1 status. There has to be that common ownership. Now, generally speaking, you want to show at least 50.1% common ownership between the two entities. There are situations where an individual or another company may own less than 50% of either the U.S. company or the foreign company and still qualify for L1 status if we can demonstrate that particular individual, group of individuals or company has the controlling interest or share of the organizations and controls the operations of both of those organizations. It's a little bit more tricky, but it can be done. We also need to show that both the U.S. entity and the foreign entity are active commercial entities, meaning they are actively doing business. So the government will want to see financial documents from the foreign entity showing that they are active, that they have revenue. Typically, the documentation would include things like tax returns or audited financial statements. In the absence of that, we would show invoices and bank statements to show that foreign entity outside the U.S. is operational. Government will also want to see an organizational chart for the foreign entity, as well as pay stubs for other employees, again, to show that it is an active foreign commercial enterprise. Likewise, the same documentation would be needed for the U.S. company. Latest tax returns, audited financial statements, possibly bank account statements, invoices with customers to show that the company is doing business. Now, there is the concept of what's called a new office L. A new office L is for a foreign company that is coming to the U.S. to establish a new company, either that has not been operational at all or has been operational for less than a year. Now, in that case, you don't have to show revenue for the U.S. company because it hasn't been established yet, but you have to set up the U.S. company. You have to create a business entity, whether it be a corporation or an LLC or some other type of legal commercial entity. You have to get a tax identification number for the company. You'll want to get an office space or type of leased premises for the company, as well as bank account statements for the company. Now, a new Office L would be issued for 1 year, as opposed to the typical up to 3 years for your usual L1 or L1B status. And at the end of that 1 year, you will need to demonstrate that the company is in fact doing business and has grown and has generated revenue and ideally hired some other individuals. One of the key aspects of a new Office L is going to be the development of a business plan to show how the foreign company expects to grow the U.S. company in terms of revenue and personnel as well, and what your marketing plans are to do that. Now, how do we apply for L1 status? How you apply generally is you first have to file an application with the USCIS, the United States Citizenship and Immigration Services. You file what's called an I-129 petition with the Immigration Service. The normal processing time for an I-129 is roughly 3 to 4 months. You can elect to do what's called premium processing, which is what I like to call a legalized bribe, where you pay the government an additional filing fee. When I say additional, it means more than the typical filing fee, and they'll process it within 15 days. Now, process within 15 days doesn't necessarily mean you'll get an approval in 15 days. You may get what's called a request for evidence, or RFE for short. An RFE is not unusual with L1s, particularly with new Office Ls, and it's the government's way of requesting more information to support the application. If you do premium processing, you get an RFE within that 15-day period. You will then have usually between 60 to 90 days to respond to the RFE. Once the government receives your response to the RFE, then they have an additional 15 days to complete the processing of the application. Once the application is approved, whether an RFE is issued or not, you'll get an approval notice. Unless you're a Canadian citizen, you will need to get a visa stamp in your passport. So you'll need to make an appointment at a U.S. consulate, wherever you are located, complete what's called a DS-160 form online, which is a non-immigrant visa application, appear for an interview. Typically, the interviews are very short. If you have an approval notice already from the Immigration Service, 9 times out of 10, it's just a perfunctory interview, and you would then get your visa stamp in your passport, usually in about a week or two. And from there, you're free to enter the U.S. during the validity of that visa stamp as many times as you like. More often than not, visas are what are called multiple entry visas. Depending on what country you're from, you may get a single entry visa. Now, if you're a Canadian citizen, the process is a little different because Canadian citizens don't require visas. So a Canadian citizen could take the application package, which would be the I-129 form, all the supporting documents, the support letter, the business plans, the financial documents we talked about earlier, copies of lease leases, bank statements, et cetera, either to the border if they are crossing by car or at the airport. They would present the documents to the immigration authorities there, and they would adjudicate it on the spot and hopefully admit you in either L1A or L1B status. The L1 is an excellent tool to transfer individuals who are coming to the U.S. to work for a related company in the U.S. It's also an excellent tool for an individual or company that is looking to set up a new company in the U.S. and transfer someone to head up the setup of that company. The documentation for an L1 is significant. As I mentioned earlier, the financial documents for both entities are key, showing that it's an existing company in the U.S. already, that it is an active commercial enterprise doing business. If it's a new office in the U.S., the business plan is going to be key, as well as all the documents to show that the business has been set up. As I mentioned earlier, the incorporation documents, the bank statements, the business plan, a lease for office space. Those are the types of documentation you will need to present. But as I mentioned earlier, the L1 is an excellent tool for either a company with offices in the U.S. and outside the U.S. to transfer individuals between the two entities, or someone who has a company outside the U.S. looking to set up an office here in the U.S.